News. On the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
And it's Friday, and it's time for Stan Pierchoski and Bulletproof Estate Planning. Good morning, Stan.
Good morning, Jeff. And it is Friday, and it is time for that.
It is time. We've made it all the way around the clock and all the way around the week, and just about to finish up the month.
Yeah. Well, Friday was slow to come this week for some reason. Usually it seems like I'm here quickly. It just seemed like this week was a little longer than normal.
Long week so far.
Well, it was. We had some issues this week that commanded a lot of my time, so I think that's what it was. It was a little unusual, but anyway, we're here, and it's good to be Friday. Looks like a pretty banner weekend coming up.
Yes, it's going to be a beautiful weekend.
But here's what's going to happen: the tree's going to bud.
Yes.
The things that hibernate are kind of come out.
Yes.
And don't forget, it's still February. It's going to be March here soon, but it's going to freeze
That's true.
again. It's going to freeze again. I guarantee it does it every year.
Every year. I always tell, Teresa always looks for those buttercups, daffodils really, but buttercups we call them commonly. And I said, as soon as those things come out, it's going to snow.
Yep. And they can handle the snow. They usually live through it.
Yeah, they do. They do.
But that happens every year. The trees will bud, and then we get a freeze, and everybody's like, "Oh, the trees are ruined for the summer now." But they always come back.
They go. We always start thinking about gardening, even though I'm not a gardener.
Don't plant; you'll be sorry.
Yeah,
it's too early. God knows; He knows.
I had a good friend, Mr. Buford Springer, who's passed on to be with the Lord now, and his wife said he plants 2 gardens every year. He gets anxious and plants it, and then it.
Oh, yeah, that's right. Then
it has to plant it again.
Yeah. Well, that's a true gardener. He's eternally hopeful.
That's right.
One of these years, it's like I'm going to get a jump on everything. It won't freeze, and I'll be way ahead of everybody. Oh well.
There used to be a race among men that I was friends with to see who could get the first ripe tomato.
Oh, okay.
That was a big deal to get the very first ripe, tomato. So.
Now, I know we're getting off track, but my wife has these big plants that she had me bring into the garage for the winter.
Yeah.
They're in the really big pots because they're out on the deck and stuff. She brought them in. And one of them was next to her. She grows these little cherry tomato plants in the summertime, in pots out in the back, right?
Yeah.
And one of them apparently had one or something like that. I could put it in the garage. And she's in the garage one day, and she said, "Look at that, there's a tomato plant in that, with that, it's not a fern, but it's an outside plant, right?"
Yeah.
And it had a bunch of green tomatoes on it. It was in my garage. So about a week or two later, I come home and she had a bowl of little round cherry tomatoes. And they looked really good. They were really bright. And I said, "Oh, those look good." She goes, "I got those from the garage plant." So I might have won the right tomato.
You might have done it.
That was like probably 3 or 4 weeks ago.
Yeah, that's pretty cool.
Anyway, I didn't know my garage would work as a greenhouse.
I didn't. That's kind of a neat thing to know. Now you know.
There you go.
Now you know.
So we were going to talk about the State of the Union, but we decided, it's bulletproof estate planning. We probably ought to stick with the scheduled subject, right?
Yeah.
Well, you know what? Let's see if we can tie the two together.
Can we tie the two together? By the way, the phone lines are open for you. 766-9393.
Good. I always forget.
Yep.
Call in if you want to talk or have a comment, question, or just share an experience.
That's right.
931-766-9393. And I did that without even looking.
You did it.
I guess we could tie the two together because if we're going to nuke Iran, it might start some issues, and you might want to get your state in order.
Yeah. Yeah, that's true. That's true. Yeah, if the end of the world is coming, you need to get all things in order.
It's the end of a little piece of the world.
That's right. That's right.
And long overdue.
Oh my.
So anyway, let me just hit some preliminaries, and that is our seminar's coming up, and it's going to be here. So it's less than a month now, or right at a month.
Yeah.
It's March the 28th. And March 28th is a Saturday. We're going to do it right here at the WLX radio station.
Yeah.
We do Saturday seminars at 10 o'clock in the morning. It's called Will's Trust in the Nursing Home. And that's what we're going to talk about. We're going to talk a little bit about will versus trust. So we're talking about wills, we're talking about trust, how they, what they do, what they do, one better than the other. Then we move into the asset protection trust that you hear me talk about a lot.
Oh yeah.
And I talk about it a lot because it's so popular. It really is popular. Once you hear what it does, you'll like it.
Sure.
I guarantee you. But that's going to be that Saturday, March 28th at 12, right here in the back of the building. WLX in the back of the building there, where they do picking and grinning and dancing on Saturday night.
Yeah, that's right.
So come to the parking lot. If you want to come to the parking lot. The radio station's in the front. Don't go in that door. It'll probably be locked. But if you go to the back of the building, there's a double door. Doesn't really have a sign there.
Yeah.
Because they call it the Country Cafe, but it's not. It's not a cafe.
There's no food.
That's right. You know, I think
It's
I
a
told you,
music cafe.
I told you before. I had somebody that was driving a couple of hours
Yeah.
to come, and they said that's what they said. Well, if we get there, it's okay. If we stay late, we'll just stay there and have lunch. I said, well, not that kind of cafe, but
Yeah.
so anyway, but there's plenty of other places, but
Yeah.
just not that one. So, but yeah, it's I'll bring it up again at the end of the hour. If you hadn't been to one of my live seminars, you might want to come. I get a lot of good referrals, and I get a lot of good reviews about the seminars.
Yeah.
And I get a lot of people that refer it. Dealt with a couple just yesterday. It was doing an amendment to a trust they did a couple of years ago. And they were asking about when the next one was because they had two couples that wanted to know.
Sure.
Yeah, so so that word of mouth is just the best business people can get.
I agree.
You have to market in the real world, but I mean that's the best business there is.
Yeah.
So
Yeah, I agree, buddy.
So what am I going to talk about today? Well, I was going to tell a story, but it makes me mad.
Uh-oh. Well, that'll be fun for me.
But they probably would.
Yeah.
It's a 10 care story. And I think a little while ago I brought it up and said I would discuss it more fully later on.
Yes.
So it's actually, everything turned out positive. Okay, we got everything we wanted in the end.
Yeah.
And it didn't take, it wasn't one of those ones that dragged out forever, but it was worse than the Keystone Cop movie, really.
Oh,
and it was
my.
just aggravating on our end because, anyway, I'll just tell the story. I won't name the facilities and I won't name the people, but I'll just give you the facts. And
Sure.
We anyway, when I tell this story, the question I'm going to ask at the end of it is, if you have a loved one that's headed for long-term care, do you really want to try to fill out the application and do it yourself?
Yes.
That's going to be the question at the end. But somebody came to me and said, their loved one was in long-term care. And it was a situation where they were going to be there for a while.
Yeah.
Okay, if not for the rest of their life.
Yeah.
And so they came to me and I said, sure, that's what we do. And so we gathered the facts, talked to them. And they were over-resourced as they had stood, so they wouldn't have been eligible. So we do what we do with the resources by modifying them, recategorizing them. There was an extra piece of real estate there. There was too much money in the bank, stuff like that. So we modify that and change it from a countable asset to a non-countable asset.
Right.
And while we're doing that, because it takes us a couple of weeks, depending on the assets, to do that.
Sure.
Because I'm not going to file an application until you're eligible. And if you're over-resourced,
You just get rejected.
They're just going to tell you no.
Yeah.
Right? So as I'm filing it, maybe we're just days or a week away from filing it.
Right.
I find out from the facility, because the gal mentioned to the facility that they had hired me. Now, this is a person who had some physical problems, not mental.
Yes.
So her mental acuity was great. I communicated with her directly in the facility. She had physical issues that kept her in care. Right?
Yes.
And so, she signed things. It's probably more often than not that the people we deal with have a power of attorney acting for them because their cognitive ability has declined.
Yes.
And that's usually more common, but it doesn't have to be that way. In this case, it was not. So this person was very, very sharp, very alert. And so I think they called me and said they were talking to somebody at the facility, and they said that they had, she told somebody that I'm hiring Mr. Pierchoski for my eligibility and to file the 10-K application.
Yeah.
And somebody told her, well, we already filed the 10-K application at the facility. And then she asked a few questions and didn't get too many answers, so she contacted me and told me that, and I said, I guess my response was like, the hell you say?
Yeah.
I said, did you do it? She said, no, I don't know what they're talking about. That's just what they told me. So I got a hold of them and said, may I please see that? And
Yeah.
then there's the thing, what they call the 10-Care Connect portal. It's an electronic way to.
Right.
I don't typically use it because I don't trust it, but that's where it was. So I got the application, I looked at it, and they filled it out, and it had her signature on it. I asked her, I took it to her and showed it to her, and said, is that your signature? And she said, kind of looks like it, but she said, I do not remember anybody talking to me about this, and I sure don't remember signing this document, but it kind of looks like my signature. So I don't know if she signed it or not, but it set off my alarm bells.
Sure.
But the thing was, so that's mistake number one. Okay, I mean, I don't think she signed it. Okay, now I don't know what that is. It's probably some kind of fraud, if not forgery or something else.
Sure, goodness.
But we'll give them the benefit of the doubt and say maybe they just gave it to her to sign it. She said nobody explained to me what it was if I did sign it.
Yeah.
And I believe her because she was mentally acute.
Yes.
Normally if somebody tells me that who's in and out, or I just say, yeah, we'll just go with it. Right?
Yeah.
But so mistake number one, they didn't make it clear that she's the one who signed it. Okay.
Yeah.
Now then we started looking at the application. It had all her resources on it. Okay. It had all the money she had in the bank that she disclosed to us, had the other piece of real estate, which is a countable asset. Other meaning a piece of real estate that was not the primary residence.
Yeah.
You know, and all the other assets she had on the application that they submitted. And now, I call that mistake number 2, because if they came to her, if they're going to do this for somebody, let's assume they came to her. I'll give them the benefit of the doubt and say they came to her and said, we'll file, because I've heard this before, we'll file your 10-care application for you, the facility.
Yeah.
And they said, we'll do it for free and we'll file it for you. Because they usually have at least one individual or more than one that are like a 10-care eligibility people or specialists or something.
Yeah, it's how they get their money.
Now, well, if you are somebody that comes and says, we'll file this application for you, does that not raise some sort of expectation somewhere that they know what they're doing when they fill out the application?
Well, it should.
Doesn't it? I mean,
it should,
especially if you
yes.
call yourself a 10-care application helper or administrator or whatever you're calling yourself.
Yes.
It indicates you know what you're doing.
Yeah.
Well, I looked at the application and it listed all the assets that they had. Now,
Yeah.
when you send that in, it doesn't take a PhD to know that it's going to be denied right out of the gate for being over-resourced. I mean, its half-life is like a week. It can't survive.
Yeah.
And so, that was what I call mistake number 2. So then I got in there and I was able to yank the application. It hadn't been, it kind of was denied, but it was still in the process that I was able to get her to sign up, something making me a 10-care authorized representative, and I was able to withdraw it.
So you withdrew the application?
I did, because there's some disadvantage to being the second application versus the original.
Yes.
So I withdrew it. And then, so we adjusted everything the way it's supposed to be, and then we filed the application, okay? Well, when you file the application, you've heard me say many times that when you file a 10-care application, there's always a rush. I call it hurry up and wait. You want to hurry up and get that application filed.
Yeah.
Because once you file it, you get this special status. Okay?
Yeah.
But you don't want to file it until you're eligible.
Right.
Because once you file it, they're going to look at it to see if on the day of the application, were you below your resource limit, were you below your income limit, were you medically needy, and so they're going to look at it. So we take the time to fix everything before we file it.
Right.
Because I'm not going to put in an application unless you're 200% eligible.
Yes.
So it took us a little bit of time. We filed that, and that is a red letter date because now your 10-care application pending. That's a special status, and the best way I can describe that is the facility now has to treat you as if you have already been approved. Okay?
Yes.
Now, what that means is, once you file it, the only thing you have to pay now is the patient liability, and the patient liability is typically your income.
Yes.
There's a few things you can take out of that, but basically, the rule of thumb is all your income goes to the cost of care.
Right.
So if you've got a $10,000 bill a month, and let's say, easy numbers, you got $2,000 worth of income, you pay your income because you're living there, they're taking care of you, and 10-care will pay the rest. Now, when you file the application, it takes 10-care, they got 90 days. So we're talking about 3 months that the facility's not going to get paid.
Right.
But what happens is, if you file the application the way I do, and I know they're going to grant eligibility when they finally get around to looking at it. So let's just say you file it, 3 months later they pick it up and they look at it, and they say, okay, we approve. What they're going to do is go back to the day it was filed and pay the facility for those 3 months.
Right.
Because the theory is, even though we looked at it 90 days later and you're approved, the theory is you were approved when you filed it. So
Yes.
If the machine could work fast enough, we should have been paying from that date forward.
Sure.
Right?
Sure.
If you could get instant eligibility, it would start paying right away. Well, it doesn't. And sometimes it takes a little more than 3 months, right?
Right.
You've heard me talk about some cases that drag out. Well, one of the things that came up was this impatientness. Now, again, you have a facility that takes 10-care beds, right? Is there not an expectation that they know and understand the 10-care rules? I mean, is that not a reasonable assumption?
You would think, yes.
Okay. Now, if you were doing it yourself, that's the conclusion you would come to, that they know and understand how this works, right? Now, I'm not talking about all the facilities. I'm talking about the one I'm talking about. I'm just not going to name it. I've seen similar things with other ones, but anyway, so I want to say somewhere around 6 weeks, month and a half, just under 2 months, they get a bill for like $10 or $12 or $14,000.
Okay.
And I get up with them and say, we're pending status. When they grant approval, you'll get paid. I kind of in so many words, say something like, look, since you agree to take TennCare patients, you agree to all the rules that go with TennCare.
Right.
And that's the rule. You'll get paid. You're just not going to get it until the approval comes in, because that's just the way it works. You got quite a few beds here. I'm sure it worked exactly that way for them.
Right.
And so, anyway, they got a little fussy because they didn't. I instructed my clients, just keep paying the income, the $2,000, because it's called the patient liability.
Right.
And when you get your approval letter, TennCare will figure out what your patient liability is, and we usually calculate it, and we're always within $1. You know what I mean? So it's going to continue on when they finally approve it. And if there is a difference, we either pick it up or credit it forward, something like that. But the difference won't be much. So they get a letter. So that's mistake number 3. They're asking for money, and there's a statute that says then they reached out to other family members and said, can you pay this bill? And there's a statute that says you cannot require like a promise to pay or a promissory note from somebody other than the patient for continued enrollment. Okay, so that's mistake number 3. They violated a rule that you're not even allowed to ask.
Yeah.
Which is unusual in statutory construction. I mean, you can't do it, but you couldn't even request it according to the statutes. And that's a problem, because that's borderline criminal activity.
Sure.
Okay, so that's mistake number 3. Then mistake number 3 would have been not understanding we're in pending status. Mistake number 4 is reaching out to other family members.
Yeah.
So that didn't work, because I advised the family, no, this bill does not impute upon you under any circumstances whatsoever. I mean, the only way you could start paying the bill for your loved one is if you say, yeah, okay, I'll send you so much a month. I mean, now you're agreeing by contract to do it. It can't come to you just because it's a loved one. And it's certainly during the pending process, because they're going to get their money. Okay.
Right.
So now, I started getting discussions with them, and they kept telling the client, said, listen, you pay us the full amount. And if it's like Mr. Pierchoski says, and you get eligible, then they can't double dip now. Let's say you pay the 3 months, $30,000.
Right.
And now you get the approval, and TennCare goes back and pays from the day of the application. The $8,000 is due, so that's $24,000, right?
Yeah.
Well, they would have overpaid, and they can't double dip. They just said you're just overpaying. If you get approved, then we'll refund the money. We'll refund the overpayment to you. But they don't want. They're in a position they don't want to take a risk, right?
Yeah.
And so here's mistake number 5. That if I just go to all this trouble to get somebody eligible, get them down below $2,000 worth of accountable assets, and then 3 months into it, TennCare gets the approval letter, which to me is the goal line.
Yeah.
Touchdown, ready to spike the ball.
Yeah.
And they say, oh, by the way, since you paid me all this time, we're going to refund you the $24,000 of overpayment. They've just instantly destroyed all the eligibility I put together, because now a person suddenly has $24,000 of accountable assets.
Yeah.
So that's mistake number 5. All right. Now that's what they were planning to do. And so we put a kibosh on that. And they were getting frustrated, I guess. They kind of like don't talk to me. They kind of talk to my patient who doesn't understand, and gets them fired up and worried.
Yep.
And they tell me, and then I take care of it. But then they sent out a letter and said, we're going to involuntarily discharge. Now, they can't do that by letter. There has to be something called an notice of involuntary discharge, right?
Yeah.
They said, we're going to involuntarily discharge the patient, okay? That's mistake number 6, because it's federal law. It's actually a crime to discharge somebody, involuntarily discharge someone who's on application pending status.
Yeah.
Now we're getting into some felonies, okay?
Yeah.
But they didn't do anything yet. They just said they were going to do it, right? And now, in the letter, it said we're going to file this in 10 days on such and such a date they gave.
Yeah.
It said you need to tell us where you want us to put them, what facility you want to put them in, okay? Which is mistake number 6. No, number 7. Mistake number 7 now, because the law says if a facility moves somebody or moves them, they have to move them to a place where they'll get the proper care that they need.
Yeah.
You don't go to the family and say, where do you want them to go? And then we just tell you where we don't. They have to maintain the proper care, and they're the ones that they have to place them.
Yeah.
Okay? And they said, you tell us where to do it. And then the letter went further and said, if you don't tell us by these 10 days, we're going to bring them to, and they gave the address of where they lived. Their house address.
Oh my.
Meaning they're going to drop them off at the doorstep.
Just put them at the house.
That's mistake number 8. That's a crime. That's
Oh my gosh.
That's a federal crime. And again, remember what I said earlier? Do we not have an expectation at some point earlier that they know what they're doing?
It seems like they don't.
It sure does. Okay. And so let's see. It seems like I got up to 10. When I was thinking through it.
Yeah.
I've been trying to keep track of them. I think that's 8.
Yeah.
Then they said we're going to issue a notice of involuntary discharge. And so I got involved and I wrote and said, listen, send me a copy of the involuntary discharge. I said, because my client wants to exercise the appeal rights that they have.
Yeah.
And then they came to my client and said, your attorney said something about appealing, but if you can appeal, but have already discharged him. Okay, that's mistake number 9, because the statutes say once you appeal, the pending status state, you cannot remove somebody whose status is pending.
Right.
Okay?
Right.
And the other thing is, mistake number 10 was this whole thing was about they want to discharge him because he's not paying. Right? They think he had this big bill, and they're saying we can discharge somebody for not paying, and you can if they're private paying, they're not paying.
Right.
But there's federal statute that says you absolutely positively cannot discharge somebody for not paying if their application is pending, because we haven't decided whether he's going to pay or we're going to pay.
Right. So,
I could probably come up with more, but it was very aggravating. So finally, bottom line, when I finally reached a point where I said I had enough. Okay, I mean, I put up with a lot. I want to have a good relationship with these facilities, right?
Right.
But if you push hard enough, eventually I'm going to push back,
Yeah.
And when I push back, the only thing I can say is we've reached a point where you just picked a fight with the toughest kid on the block.
Yeah.
I've had it, okay?
Yeah.
So I've drafted all these mistakes out. And in every mistake, I cited the federal statutes or the 10-care statute that supported what they should have done versus what they really did do.
Yeah.
And stuff like that. And all the mistakes, stuff like that. And I sent it to them. I also sent it to the 10-care ombudsman, which, there's a thing called 10-care ombudsman. And
what is that? Explain that.
You know what? I always wondered, what does the 10-care ombudsman do? I've read the statutes. It's a 10-care position, but they're supposed to be advocate.
Okay.
And I've read through it, and it sounded more like if you had a grievance at the facility.
Yeah.
But I thought, well, I'm just going to include them and see what they do. I don't know what exactly they do. I've attached them to several emails before.
Yeah.
And one time they responded to one, but they didn't really do anything. So I sent it to them, and I pretty much said, I want relief for my patient because you got a rogue facility here. And here's what they did.
Yeah.
Here's what they should have done. Here's why they couldn't do what they did.
Yeah.
And I even told them that I said, if you want somebody's back payments, there's something called IME, stands for incurred medical expenses. They have a back balance from somewhere.
Yeah.
He didn't have one, but if there's something they could do. So anyway, I sent it to the ombudsman. I sent it to them. And at that point, it was silencio. The day that they were going to file the involuntary discharge notice, it never came out.
Okay.
Because I asked them, I said, as soon as you get one, find a way to scan it, copy it, and send it to me. And I told them to send it to me, but I figured they probably wouldn't.
Yeah.
And they never got issued. Well, this was probably 2 weeks ago, 3 weeks ago.
Yeah.
And this week, I get this big fat letter in the mail with a green card on the back, like certified mail and stuff like that, from the facility.
Yeah.
I thought, okay, this will be fun. Anyway, I open it up, and it's pretty much them saying, well, they didn't say you were right, but they just kind of said, well, we're just going to continue keeping him here, and in hopes that it becomes eligible, and they'll 10-care will pay the bill. And in the meantime, that's what happened.
Wow.
And they didn't come out and say we were wrong or we're sorry. Yeah. They just kind of said, well, we're not going to do what we threatened to do because we're just not going to do it.
Yeah.
So and I don't want to be that. I don't want to be that person.
Yeah.
But my client hires me to be on their side.
Sure.
And the rules are fully in favor of what we did. And every turn, they're circumventing it.
Yeah.
Now, what I get mad about is this concept of, hey, we got a whole department that handles 10-care applications. They don't. I don't know what they do, but that's not handling it. That's screwing it up pretty bad. And I don't know if, like I said, I'm not going to be all-inclusive and say all the facilities, because I guarantee some of the ones I deal with are somewhat a pleasure to deal with. They know what sometimes they get, I got some that get stumped on other patients and call me and ask questions. It's just great. That's the kind of relationship I want. Yeah. Because I got a lot of clients and they're in many different facilities. Yeah. So I don't want to be the guy that cracks the whip, but at some point you just have to put them straight. And I don't know who was guiding this, because the person I dealt with was on board. She was a very nice person. But I know it was coming from up above. Yeah. Because she actually kind of said that. But anyway, it was just a...
If I was a facilities manager, I would have you almost on staff. or
Well,
somebody like you? Because it looks to me like it would be the smoothest way to get the state money.
I've had that offer, but I want to work on this end of it.
Well, I understand that, but I'm just saying, yeah, you know what I'm saying. I mean, it would be advantageous of the facility to have somebody that can smooth these applications perfectly.
I've had those people refer people to me that were having trouble trying to get eligible.
Yeah.
They said, go to this guy, and he'll get you that way.
Yeah.
So
that's the way it should be.
But you know, like again, the story's not about me. It was about the calamity of errors.
Yeah.
And the misunderstanding of the basic fundamental rules. Now, you know, if you're listening to me in the radio and you think, well, I didn't know that. Well, you have a reason for not knowing that, right?
Yeah.
You're not educated.
Not in that world.
You're not schooled in what the 10-carat rule is. And I don't expect you to be. I mean, you might be driving around, but when you're in a facility of providing care and you have an administrative department that helps people with their 10-carat eligibility, why would you file an application that you know? I think that was another error I forgot to mention. When you put all those assets down there and you mail it in, if you know what you're doing, then you have to know it's going to be denied. Now, it's wrong to file an application that you know is going to be denied.
I have a theory.
That's a borderline fraud thing because you know you're asking for benefits that you know you're not entitled to, but you're asking for them anyway. That's as bad as lying on the application. Because you're not entitled to it, you know you're not entitled to it, so you lie on the application and say you don't have what you have to get the benefits. But if you can file an application that fully shows that you're not entitled to them, but you file it anyway, I think that's actionable. I've never seen it done, but I'll bet if I...
Do you think the facility just assumed that it would be great to go ahead and do it, and then they'll just self-pay till all the assets are gone?
That's exactly what they do.
That's what they, you know...
That application never had a chance to come back because I pulled it.
Yeah.
But if it did come back, here's what I've had happen in other cases. They go to the patient and say, hey, Aunt Gertrude, we filed your application for you. It came back denied because you were over-resourced. That's the language it would have on it.
Right.
It says you're over-resourced. Just keep paying our bill until it's all gone, and we'll file it again.
Yeah.
Now, I don't think they do that to be evil. I think that's just the way they think they should do it.
That's just the way they think it is. And it doesn't have to be.
And, I mean, that is, I'll say this, that is a way that will work.
Yeah.
But if you're going to do that, you don't need me to get you eligible. You'll be eligible by default when you're broke.
Yeah.
You know, I don't do that. I do what people have a lifetime of assets and want to hang on to it. That's what I do. I mean, you don't need me if you're just going to pay it all on the cost of care and then have nothing left.
Yeah. Yeah, yeah.
You'll get there on your own.
That's what your services are all about.
That's right. And people constantly ask me, how can I protect my stuff?
Yeah.
This is how we do it.
Yeah.
And that's what we protect it from.
All right. Well, we do have our caller want to talk to us. And good morning.
Yes, can you hear me okay?
We can.
Okay, somebody called in Dave Ramsey this last week about that. It sounded like this lady, now I couldn't tell, she had some kind of anxiety disorder, obviously. I mean, she even admitted she did, but she had put her husband in a nursing home, and she thought it was under Medicaid. She did the paperwork. She had problems.
Oh, I'm losing her there.
Dave Ramsey finally just said, you're going to have to talk to an attorney because it sounds like you didn't qualify for Medicaid. That's the way it ended. Now, I have something that has to do with trust, but it really doesn't have to do with Medicaid. Someone told me that they had been with relatives from another state in the Northeast and were shocked. It was a second marriage for each. They both have children, highly educated with good jobs, property out of the country, plus 2 homes, and they don't even have a will. Now, my first thought was maybe they have a prenup. They definitely need a prenup or a trust. So I went to that state, and it said in that state, it's your second marriage, and each husband and wife have children, that it goes by the bloodline. If without a will or legally adopting the children, the non-bloodline children, in other words, the kids that are left that weren't the bloodline, they don't get anything. So I was wondering how things like that work in Tennessee. And also, when they have somebody has property outside the country, has that ever been a factor in trust that he deals with? Because I keep thinking about how we honor wills or things made in other states. But they can't violate our laws and stuff. I just was wondering how that would work in Tennessee. Basically, the person they were talking about grew up in Tennessee, might move back eventually, but I thought, what a mess if they don't even have a will spelling out some of this. Some of those points. Does he understand?
I think so.
Yes, I can handle that.
All right.
Well, first of all, there's a lot of questions in there. I'm going to try to distill it down to it.
Yeah.
I think I'll start with the very first one. Actually, the caller dropped out for about 5 seconds.
Yeah.
And then I didn't hear the middle part of it, but it said, go see an attorney. It sounds like you didn't qualify.
They didn't
and that's probably
qualify.
exactly what happened. They did
qualify.
do-it-yourself application, don't understand what the qualification rules are.
Right.
And they just applied them, and they didn't. So I need more on that to talk about it. But the trust thing, what you said is exactly right, and one of the last things you said is exactly right. It's a real mess.
It's a real mess.
So all states, you know, a will is governed by state law,
Yes.
and which is usually called the testate code or the intestate code, is without a will.
Yeah.
And it's usually governed by state law, but the states are very similar. So I don't know what states you're talking about, but I'm pretty confident that if you pass away without a will, and I say this at my seminars, that if you don't have a will, the state writes one for you.
Yeah.
And it is called the laws of intestate succession. Okay?
Yeah.
And because, you know, and they've already written it. They know who's going to get your stuff, what percentages and everything. And you say, well, how can that be? Well, it has to go somewhere. So if you're not going to make any arrangements for where it goes, it can't just hang out there in limbo, right? So it has to transfer somewhere. So if you don't make a will, there's like a hierarchy of people that it starts looking to how to distribute it. So here in Tennessee, and I'm pretty sure this is probably nationally, is if it's a first death, so you're talking about a blended family and stuff.
Yeah.
Well, you have a first death and a second death, okay? At the first death, it's going to say, okay, do you have, intestate succession rules are going to say, is there a surviving spouse? And at the first death, it would be yes, right?
Yeah.
And then the next question is, do you have any descendants? When you say descendants, it's just like she said, we're talking about bloodline,
Yeah.
which would include legally adopted,
Yeah.
not stepsons, not stepchildren.
Right.
So and it says, okay, let's just say, let's make it simple. Let's say you do have a surviving spouse and you have 3 children that are yours.
Yeah.
Okay, when you went into this blended marriage, you had 3 of your own and your spouse had 2 of their own, right? So
Yeah.
at your death, and you don't have a will, say, okay, we're going to write a will for you. It's the laws of intestate succession. So we're going to say, is there a surviving spouse? Yes. Do you have surviving children? Yes. How many? 3. Or do you have descendants? Yes, 3. Okay, so that's the end of the search.
Yeah.
And what we're going to do is, our statute in Tennessee says the surviving spouse gets a third or up to a child share. Now, the only time it's anything other than a third is if you only have 1 child. Then it would be
Okay.
half. But they got the 3 kids, so the surviving spouse gets a third of it, and the 3 bloodline children, the descendants, get each a third of the other 2/3,
Yes.
which is a ninth, right?
Right.
Or I'm sorry, it's a third of 2/3 would be 2 ninths each, right?
Yes.
Yeah, I can do the
You're
fraction.
hurting my brain a
I'll
little
do the
bit.
fraction in my head. Yeah, that'd be right. I mean, 2 ninths, 2 ninths, and 2 ninths, 6 ninths, and the other person has a third, which is 3/3, or
Yes.
1/3 or 3 ninths.
Yes.
That's all 9 ninths. Okay.
All right. Well, you're with me. I've got you.
Anyway, we divide it up that way. Now, if the spouse is not, so you don't have a surviving spouse, let's go. Now, in this blended family she's talking about it, only those 3 descendants of that deceased first spouse, the first spouse to die, is in that equation.
Yes.
Your new spouse has 2 descendants, they're not in there,
Right.
unless you adopt them. Because once you adopt a child, by law, it's a biological child. And I know it's not technically a biological, but by law, it's
By
treated
law
as
it
one.
is.
So that all went there and stayed right there, except for the third. The third that went to the spouse. Here's where the danger can lie with intestate succession. Then when the second spouse dies, if he doesn't have a will, that third he inherited from the spouse goes to his children.
Okay.
Because he doesn't have a surviving spouse at death, because assuming he doesn't remarry. Right?
Yeah.
And so that goes to those children. So that's a third of what the deceased person had that probably wanted it to go to their kids, ended up with somebody else's kids because they didn't do anything.
Wow.
And like I said, so that's, and then if you don't have it's like a hierarchy of search. First they say, do you have a spouse and or children? If the answer to that is no, well, let me back up a little bit. Let's say you have, yes, I have 3 children, one's deceased.
Yes.
But that deceased child had 3 children.
Yes.
That 2/9 that went to that child flows through the deceased child and gets divided 3 ways among his 3 children.
That's correct.
So now it's a third of 2/9, right?
Yeah.
Which, I can do the fractions in my head, but it doesn't mean anything on radio, but it's,
Yeah.
it gets diluted from there, you know what I mean?
That's right.
But it keeps flowing, just because a person, it's not the then living descendants.
Yeah.
That's some things we sometimes put in trust, but you have to say it.
Yeah.
But if you don't have a will that dictates where it goes, that's where it's gonna go. It's gonna
Yeah.
keep going from there. If one of those predeceases and has children, it just kind
Right.
of flows on.
Right.
So let's say you don't have a spouse and you don't have children. Now it looks upwards to see if your parents are alive. I always think that was kind of crazy. Why? It's not likely that's going to happen, but
Right.
I guess it's possible.
Yeah.
It looks up to see if your mom and dad are alive, paternal or paternal.
Right.
If they're not alive, then it looks sideways to siblings.
Yep.
And when you get to the siblings sideways, then it starts moving down the nieces and nephew branches as
Right.
well. I mean, there's this hierarchy that goes on for a long time, looking for somebody to give to. Usually you don't get that far into
Yeah.
it, but it's all there. So when she says it's a mess, I mean, that's the kind of mess you have, especially with a blended family. Now, if you take a couple that's not a blended family, they got 3 kids, they're joint kids, meaning children of both, it's not that bad of a result. I mean, it's probably not what you want, but it's not a bad result. If you first one pass away, most people would say in their will, if I pass away and I'm first, it all goes to my spouse.
Right.
But if you don't have a will, it only some of it goes to the spouse, a third.
Yeah.
And the rest of it go to the kids. Now, it's all going to your family, so it's not that hard to take. It just, the spouse may need those assets during their lifetime, or the surviving spouse may need that during their lifetime,
Yeah.
rather than just get a third of it. I mean, it's still going to end up with the kids.
Yeah.
Most commonly, people say, the reciprocal will say, if I pass away and my spouse survives me, it all goes to them.
Yeah.
If my spouse does not survive me, it goes per stirpes to my children, which is equal shares.
Yes.
So it's all going to end up with the children that
Yeah.
way after the first and second death, but it's a cumbersome way to do it, because if most assets at the first death don't require any kind of a probate action because they're all jointly held.
Mm-hmm.
And so you don't have to, if it's jointly held asset, you don't have to divide it.
Mm-mm.
But but at the second death, it most assuredly goes through probate, and that's what would happen. So you go through probate whether you have a will or not.
Yeah.
It's like I said, if you don't have a will, you end up with one.
But you can avoid probate.
Oh yeah. And then she talked about the trust, and I forget. No, she said about the trust. Could that fix that or something like that?
Yeah.
And the answer is, yeah. I mean, it can certainly. In a trust, you just say where it goes. You decide.
Yeah.
You have many choices.
Yeah.
You can say per stirpes, which is what we just talked about.
Yeah.
Or you can say per capita, which says, if I get 3 kids and one predeceases me, I want it to go back into the pot and be divided among my then living children.
Yeah.
Now that has an advantage of increasing the share that goes to the living children,
Yeah.
but it has the disadvantage, maybe not disadvantage, but it has the effect of not following the deceased child's descendants.
Yeah.
They're out of that.
And then they're
mix.
out, yeah.
But I often see that with people. People have 3 kids. One of them doesn't have any children, and for some reason not going to have any.
Yeah.
Either too old or doesn't want them or unable.
Yeah.
And so it's like, okay, I want to go per stirpes for these 2 children, but for him, I want it to be per capita. And it either goes to the other 2, or you could say, he was a vet, so I want it to go to the Wounded Warrior Foundation.
Sure.
You can say where it goes. So,
Yeah.
if you want it to go somewhere like that, we just have to say it.
Right.
Nothing happens automatically. Whatever you say is what will be enforced.
Yeah.
And
Yeah.
it works pretty good. I mean, so the big advantage of at least having a will over a no will is it all goes through probate. It all has all that ugliness that goes with it.
Right.
But the big difference in having a will or not having a will is with a will you have some say in where it's going to go,
Sure.
which is something. It's at least something.
It is something.
Yeah. Now you can certainly do that with a trust. I mean, I don't like to compare wills to trusts because you always hear me beat up on wills, right?
Yeah.
But if I compared them, they both of them distribute property after death.
Okay.
That's about the length of that's the amount of the comparison that I'll put.
Right.
But they're instruments that will distribute property after your death, and you say in there where it goes.
Which is what we want.
Well, what you want is one of the things you certainly want is that it goes where you want it to go.
Right.
Now, the Asset Protection Trust goes a little farther and says, well, if I say in my will or I say in my revocable living trust, I want my 3 kids to split and get a third of everything I have. Third of my farm, third of my bank account, third of my hard earned, worked all my life, blood, sweat, and tears, money in the bank,
Right.
stuff that I bought. I want them to all get a third of that.
Right.
Well, the presupposition there, I mean, it's a better word to be, the expectation there is that you have all that stuff at your death to give them.
Sure.
So now the next question is, what could happen during lifetime that could exhaust my estate or at least put a hurting on it, right?
Right.
Enter this high cost of long-term care.
Yeah.
So then you have the Asset Protection Trust, which also avoids probate at death, but it also has all this tremendous protection during life. Because if you
Right.
run into long-term care, it's happening while you're alive.
That's right.
That's just a pretty obvious fact, but sometimes I feel like I have to say it. And it protects it from the lifetime creditors of you. And then, you know, and that's a future creditor. Long-term care is a future creditor to you, and it's going to be one of the biggest creditors you ever run into.
Right.
I mean, I don't get people that come say, hey, I've been sued, I got a $300,000 judgment against me. I mean, that happened once. Somebody called and said that they had that judgment, and they wanted to know if the Asset Protection Trust could get them out of that. I said, well, it'll protect you from future creditors, but not existing ones.
Not existing
And,
ones.
of course, you know, an existing creditor, that's just too unfair.
Sure.
You know, it's self-serving. You can't
Sure.
just get yourself in trouble and then slap everything into a trust and tell
Sure.
them to go pack sand. It doesn't work that way.
Sure.
And the law does not support that. But it will protect from future creditors that don't exist yet.
Right.
But you got to do something to get that protection.
Right.
And that's the and it's the only protection scheme that's out there is the Asset Protection Trust. I've looked. There's nothing else that will protect. I've even looked at the foreign domestic Asset Protection Trust, where you can put your property in other foreign jurisdictions,
Really?
like Belize or the Nevis or the Cook Islands and places like that. They have these foreign asset protection trusts. You put property in there; it's under their jurisdiction. The laws have changed over the years, and those are still accessible. Okay.
Really?
Yeah, they.
That's interesting. How
Yes.
does that work?
Well, because they work with these countries, and they're like, I'm going to say like the Cayman Islands or Cook Islands. That's like their 100% source of revenue. These trusts that they write.
Interesting.
Well, other countries like our country can pretty much say to them, you know, we're going to limit your trade, or we're going to do this unless you let us access the property there, because people move it there so the government can't get at it to pay for programs, and they have slowly whittled away at that stuff. Even Swiss bank accounts.
Wow. Okay.
Yeah. They ask about if you read your 1040 tax return, and I advise you to read every word on there. If you do, you're going to find a question where they ask, do you have any foreign bank accounts?
Yeah.
And if you don't answer it, and you have one, now you're looking at
You're in trouble.
tax fraud. Right? So, yeah. So they have whittled away at that stuff. So I even looked down that route, because the United States has gone, 18 states out of the 50 have developed what they call a domestic asset protection trust, which is a little different animal than what the asset protection trust we do. It was to replace all this property that goes offshore to other places, and they wanted to try to protect it here. And it's not a tool for shielding against long-term care. It's a creditor protection thing.
Yeah.
It has a very unique fit. It fits every once in a while, but it's usually not the thing the average person would want to
Interesting.
do. But
That's
the only game in town to protect assets ahead of time, before you go into long-term care, is the Asset Protection Trust we do. We call it the Income-Only Asset Protection Trust. And that is something, it's the only available remedy when you're not in care. When you go into care, and you hear me talk about these things called crisis remedies. You know, and those are things where you can take the money and turn it into a non-countable stream of income through like a Medicaid compliant annuity, or we can give it to the spouse or shift it to the spouse under certain statutes that allow us to do that
Sure.
to a disabled child. Other things we can do, these crisis planning tools. But when you're not in crisis, meaning you're not in care or you're not really headed there right away, the Asset Protection Trust is the solution.
Right. Right.
And it's a great solution. I mean, we're so fortunate to have it here.
Yeah,
I mean,
it
all
is.
states have a version of it, but I think I said before, Tennessee's ranked number 3 on a list of 50 states for years now
Yeah.
as being the third most favorable trust laws.
That's good to know.
It is good to know.
That's good to
And
know.
we have a lot of, they have made some revisions of the trust laws over the years, not many, but they made some, but they've always been enhancing the ability to do things, not curtailing it.
Yeah.
The only person that changes law to curtail your ability to protect assets is TennCare.
Yeah.
But that's not trust law. That's just them saying, you know, this is what you have to do or can't do or stuff like
Sure.
that. And they can influence each other. A lot of times people say, what if is trust law going to change and this doesn't work all of a sudden? And the answer is no, they don't change trust law much because it's pretty much comes out of our common law jurisprudence, over the years of being
Sure.
developed. But they can influence each other. The 5-year look-back rule is a classic example.
Right.
I got just a few minutes, I might as well finish this thought, and that is, I like to say 10-care has absolutely, positively nothing to do with trust law. There's nothing the same.
Right.
By logic, trust law has absolutely nothing to do with 10-care law, right? They're completely separate statutory
Sure.
schemes, right? They have nothing to do with each other, but they can influence each other, and here's how. 10-care says, if you have an asset, and you just give it away, don't get anything for it. They call it a divestment. I usually call it a gift because gift implies you don't get anything for it.
Right.
But it's sometimes referred to as an uncompensated transfer. You can give it away.
Yep.
They say under 10-care law, if you give it away, we're going to hit you with a penalty period. If you gave it away within 60 months of applying for care.
Right.
Or benefits, okay? Now, they don't say anything about putting it in a trust. They don't say anything about giving it to your kid. They don't say anything about giving it to the church.
Yeah.
They literally say, I don't care where you give it. Some people say, but I donated it to the church. Surely it's not. They say, if you divest yourself of it and don't get anything for it, meaning you've given it away, and you did so in the last 60 months of applying for 10-care benefits, we're imposing a penalty period. Now, the way it influences our trust laws, when you put property in an asset protection trust, let's say you got $100,000 house. Nice round number. You deed your $100,000 trust you deed your $100,000 house to your asset protection trust.
Yeah.
The trust does not write you a check for $100,000 for the house.
Right.
So by definition, that qualifies under 10-care as a divestment because you're changing ownership and you're not getting paid for it.
Right.
Which is what gives us the creditor protection. But that's how the two overlap, or not overlap, but influence each other. That's how putting property in these asset protection trusts does trigger the penalty rule, does trigger the 5-year look-back rule.
Sure.
So I often say at my seminars and whenever that the goal of the asset protection trust, and I laugh when I say this, but it's exactly what the goal is. Put your property in this trust and stay the heck out of the nursing home for 5 years.
Yeah.
That's goal number one.
Yeah.
If you do, nothing in the trust can ever be used for the cost of care. Once we put it in the trust, they can't use it immediately. It's just that the only thing they can do to us is for the next 60 months, they can impose a penalty period, which would require us to private pay for a certain period of time. So they can influence each other, but they have nothing to do with each other. Now, so if something changes, somebody says, are they going to change the trust laws? No. They might change 10-care law and make it a 10-year look-back period.
Right.
That will influence us.
Wow.
And since I've been doing this, I've been waiting for that to happen.
Yeah.
I thought for sure the last administration was going to do it. I would have bet money. I mean, they talked about it twice. Both times it kind of just lost steam and went away.
Yeah.
I think it's because those people that are trying to do that utilize those rules themselves.
Yeah, I would say so.
And I know they're ignorant, they're stupid, and they're self-serving and greedy, but they don't want to shoot themselves in the foot either.
That's right. That kind of worked to our benefit in this area.
Well, that's right. It's like, unfortunately, they can't benefit them without benefiting others.
That's right.
But they didn't, and now I think it's going to be a while. Yeah. I think there's going to be some breathing room. Now, I don't know what's going to happen after this administration. I'm pretty positive it won't happen during this administration.
Right.
But afterward, I don't know. I fully expect it to happen someday.
Yeah.
Because there's just too much money there that's how they can't fund the program properly, and that's one place they can get at more property to fund the program.
Sure.
But they don't want the program to collapse, and it's got to get funded somehow. And so that's. Hopefully, all that answered the question. I kind of went above and beyond on some of it. But
I can tell you this though, just in my experiences of sometimes liquidating assets in an estate, when there's been no will and no nothing done, it sure does complicate matters in a big way. In a big way, dealt with one where there was no will and no designated heirs, and had this in this particular case, they did what you talked about, and it ended up being the estates divided between 20 some odd cousins.
That's not uncommon.
Because there was nothing done. So
I mean, you think about it. If you don't do anything within at least one or two generations, three for sure.
Yeah.
You're going to have multiple descendants.
Yeah.
I mean, unless any typical family, right?
Yeah.
Because kids have kids and their kids have kids, and it's almost exponential. You know what I mean? I had one that was in the 40s. Heirs. So now what I think is most important about what you said is because when people don't do anything, stuff like that, it was just a very complicated mess.
Yeah.
If you don't do anything, I'm going to say this again. If you don't do anything, you still go through probate.
Yeah. And
Because you'll go through probate if you have a will. But if you don't do anything, the state of Tennessee writes one for you, and so you go through probate. So what you're really saying is the probate without doing anything is super complicated, and it is.
yeah.
At least with the will, you say where it goes. You don't have all the heirs that are there by default,
Right.
like you had.
Right.
You have the heirs, you actually say where it goes.
Yeah.
So that it's even more complicated without.
And while you can, why don't you have your say so in it? That's the thing.
Absolutely. Why
While
not?
you can.
I mean, there's a presumption of the law that you want to leave your assets to your bloodline children. That's why if you don't name one, let's say you got 3 kids and you say, I want to disinherit son number 1.
Yeah.
But you just say 50% goes to the other 2, and you don't say I'm disinheriting number 1. He'd come in and say, he must have forgot about me. And that's the presumption of the law is you want to leave your bloodline children. So if your instrument is silent, then that's a valid argument.
Absolutely.
So anyway, we're getting right down to the wire. So
We are.
Seminar March 28th.
March 28th.
March 28th, Saturday, 10 o'clock in the morning, Will's Trust in the Nursing Home, right here at the back of the building of WLX radio station. Call me at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222 for information or to ask a question, or you can go to my website, estateplanStan.com.
That's right. The Estate Plan Stan, everybody. Stan Pierchoski Estate Law. And got a new office location in
I
Pulaski.
do. It's just 1 block off the square. It's at 304 West Jefferson Street. It's a house. It's pretty cool.
Yeah, I like that idea.
No, stop by if you're ever over there.
I need to stop by, and of course I've been in your other office, your older office,
So if you're over that way, stop
and
by and take a look.
I'm over there some. Need to stop in and visit. Sure enough.
Do it.
Always good to have you on Fridays. You'll be here, good Lord willing, next Friday, and we'll do it again. Right quick, we've got about 30 seconds.
I got something I want to quick say. Go ahead.
The Star Theater.
Yeah, the Star Theater, I was going to say, we're doing 1776 for the 250th. It's actually being performing in May, but I'm directing it, and I'm going to have a small role in it so I can help keep things going when the lines get flubbed up and stuff like that. But I have decided that I'm going to write a letter to President Trump and invite him to come to the play.
You should do it.
I don't know if he'll come or not, but I'm going to invite him.
He should be invited.
If he comes, I'll let you know.
I'm in. Sounds good. Thank you, Stan.
Always a pleasure.
See you next time.
We had a board meeting last night, and I wanted to talk. I said to the board, I'm pretty sure I can do this on my own volition as chairman of the board because I'm just